hope you're all well. I see we've still got people joining, so we'll do some introductions and get started very soon. There's always a bonus for being on time, so while we wait for others to join us, here's a snippet of information for you, the early joiners. Did you know that the 28th of January is Data Protection Day? It commemorates the 28th of January 1981, which was the date of the signing of Convention 108. And Convention 108 was the first legally binding international treaty dealing with privacy and data protection. So in 10 days' time, bake your cakes and celebrate Data Protection Day on the 28th of January. So good morning again, everyone. Let's get started. A very warm welcome to this Shepherd and Wedderburn Information Team webinar. My name is Joanna Boag-Thomson, and I'm a partner in Shepherd and Wedderburn's Media and Technology team with a specialism in data protection. Our other speakers will introduce themselves just shortly, but a couple of points to note first. So here we are, January 2022. It's been a full year since the end of the transition period and the end of the UK's formal compliance with EU laws. And we're now starting to see some indication of how the privacy landscape may look in the UK post-Brexit. So today we're going to cover a range of topics. We're going to do international data transfers, compensation claims from data subjects for data protection breaches, COVID-19 and the collection of health-related data, and an update on some developments at the ICO and a look at the DCMS consultation. And when we talk about GDPR today, we'll assume that the UK and EU positions are aligned. The slight exception to this is international transfers, where there are slightly different positions on standard contractual clauses. So you'll hear my colleague Ashley talking about different positions for the EU and for the UK on international transfers. Please feel free to post your questions as we go through. They're not made public, only the panel can see your questions, and we'll try to cover your points in the presentations wherever we can. So I'll now ask the panel to introduce themselves, and then we'll move straight on to our first presentation.
Hi, I'm Alison Mclean. I'm a Senior Associate at Shepherd and Wedderburn, specialising in data protection and privacy.
Hello, Alison White. I'm a consultant specialising in information management law.
Morning everyone, Matt Phillip. I'm a partner in the commercial disputes team at Shepherd's and deal with a wide range of claims, including data protection claims.
Hi everyone, I'm Joe Fitzgibbon. I'm a member of the Media and Technology team specialising in data protection.
As Joanna said, the first topic we're going to cover is international transfers. We're going to begin by going back just over 12 months and looking towards the end of the transition period. Ashley, what was the key data protection concern at that time?
So the main concern for data protection lawyers and businesses at the end of 2020 was the uncertainty around personal data transfers from the EU to the UK and the basis on which they would happen. In the run-up to the end of the Brexit transition period, there was a lot of uncertainty around what was going to happen with such transfers of personal data. The UK government made its position clear early on that it was going to roll over existing European Commission adequacy approvals, such as for New Zealand and Israel, as well as deem all EU member states and the additional EFTA member states adequate as well. It has followed through on that, and this has meant that transfers from the UK to such countries have been able to continue freely without any further review or documentation being put in place. The converse wasn't the same with the EU. As the UK was going to be a third country for data transfer purposes from January 2021, the UK needed an adequacy approval from the European Commission to allow transfers to continue freely after the grace period ended in 2021. Notwithstanding that the UK laws at that time were based on EU GDPR, the EU still had to carry out its usual adequacy approval process. An adequacy approval from the European Commission means that it has accepted local data protection laws of a country as acceptable, and no additional transfer mechanisms are required for personal data, for transfers of personal data to that country. The discussions went to the wire. It was quite a squeaky time, and it was only just before the end of June 2021 that the UK was granted formal approval as being adequate for the purposes of EU GDPR and international transfers of personal data, much to everyone's relief. So this has meant that transfers of personal data from the EU to the UK could continue to happen freely as they did before the UK left the EU. One thing to note about the UK's adequacy approval from the European Commission is that it is still subject to a 4-year review, and that time limit can become important as well, and no doubt touch on later.
And are there any other key changes to the international transfers regime that happened in 2021?
Yes, quite a big one. The other major change is around the transfer mechanism known as the Standard Contractual Clauses, or SCCs. The EU has updated the European Commission approved Standard Contractual Clauses. So you'll hear me talk about SCCs during this discussion, and when I say SCCs, I'm referring to those Standard Contractual Clauses. So Chapter 5 of EU GDPR and the UK GDPR sets out the basis on which international transfers of personal data can happen. Adequacy approvals are just one part of that. Article 46 sets out other mechanisms which allow such transfers to take place, most notably the Standard Contractual Clauses.
So you've told us about SCCs, but what actually are they and when would we want to use them?
So the idea behind the SCCs is to give some protection through contract law to personal data when it's transferred outside the EU. Where countries don't have equivalent laws in place, the SCCs are meant to fill this gap. Contract law has its limitations, however, the use of standard contract or SCCs for international transfers is very widespread because previously of the ease of use of those SCCs. The SCCs were first developed under the Data Protection Directive, which was the predecessor to EU GDPR. And although EU GDPR has now been in force for over 3 years, the previous sets of SCCs, which date from 2001 to 2010, quite a long time ago, were actually still in use until the new EU SCCs came into effect in 2021. The new SCCs were only approved by the European Commission in June last year and came into effect in September. So since September last year, any new data transferred from the EU using SCCs as a transfer mechanism must use the new form of SCCs approved by the European Commission. One of the many criticisms of the old SCCs was that they didn't reflect current business models. For example, they didn't cover controller to processor transfers or processor to sub-processor transfers. The new EU SCCs address this by having multiple options, which ensure that the SCCs best reflect the reality of the contractual relationship between the transferring parties. Previously, organisations would have to put kind of imperfect solutions in place, whereas they don't need to do that with the new EU SCCs. I guess, what does this actually mean for organisations that have currently got the old SCCs in place? So for organisations that already had the old EU SCCs in place before September last year, they now have until December 2022 to replace them with the new EU SCCs. While that is almost 11 months away, it is better to address any updating sooner rather than later, so businesses should identify any existing transfers of personal data based on the old SCCs and update them with the new SCCs. My advice would be do not leave this process until late 2022, however tempting that may be, as the new SCCs are much more than just a box-ticking exercise. Large companies could have hundreds, if not thousands, of old SCCs in place, so significant time and effort for this exercise of repapering old SCCs with new SCCs will be required.
So these SCCs, you mentioned they were approved by the European Commission. Do we use them if we're based in the UK?
Unfortunately not. So these new EU SCCs should not be used for transfers of personal data from the UK. They're not valid for international transfers of personal data from the UK because the UK was no longer part of the EU when the new EU SCCs were adopted, and the UK has not chosen since then to adopt them. So UK businesses or organisations subject to UK GDPR should continue to use the now very outdated version of the EU SCCs, i.e. the ones that the EU has just superseded. The UK GDPR specifically allows for the continued use of the old EU SCCs for existing and new international transfers from the UK. The UK Information Commissioner has done some work to bring the terminology of the old EU SECs into line with UK laws and language, and has produced a UK version of the relevant SECs, which organisations can choose to use. But rather than adopting the new EU SECs, the UK is undergoing a different process to create its own version of the SECs. The UK Information Commissioner's Office has recently closed its consultation on the new International Data Transfer Agreement, which I'll refer to as the IDTA, more acronyms for you. The intention is this IDTA, once finalised and approved, will replace the SECs currently used in the UK for transfers of personal data out of the UK. So the consultation on the IDTA closed in October last year, but there's no updated version issued as yet. We're yet to see what the new Information Commissioner is going to prioritise, but hopefully, fingers crossed, we will get UK and specific updated SECs, i.e. IDTA, before too long.
What if the UK transfers are part of a bigger arrangement which also involves transfers from the EU? What would you do then?
I mean, it's a really good question, because often that is very much the case. The UK consultation on the new IDTA recognises that under certain circumstances there may be a benefit to UK-based organisations using the new EU SECs. For example, when transfers from the UK form part of a series of transfers that include transfers from EU member states. Part of the UK consultation is a draft addendum to the new EU SECs that would make appropriate adjustments to those SECs to allow them to actually be used in a UK context. So as with the IDTA, we're still waiting on the final version of that addendum, but we do think it will prove a useful tool to avoid having different agreements in place for different jurisdictions.
And what about transfers between the EU and the US? I know it's been difficulties there. Has the issues there been resolved?
So transfers of personal data from the EU and the UK to the US have been a hot topic since the Strands 2 decision, I guess, and further back when you looked at Safe Harbour. But in 2020, the European Court of Justice considered the validity of the EU SECs as a transfer mechanism in the case of Strands 2. The case centred on the US to EU privacy shield, with the court holding that privacy shield was not a valid basis for transfers to the US, but it also looked at the SECs. So in that case, the Court of Justice made it clear that it was simply not enough to put the old form of SECs in place. The data controller making the transfer had to do a risk assessment of local laws and any additional measures that had been put in place to be able to take a view on whether personal data would be properly protected in the US. So, for example, because of government surveillance laws in the US, use of the SECs alone might not be sufficient, and other measures such as end-to-end encryption might need to be considered. This risk assessment is now required as part of putting the new EU SECs in place, but it's worth remembering that this risk assessment is also required for an international transfer of personal data from the EU, which uses one of the transfer mechanisms in Article 46, i.e. to a country that doesn't have an adequacy approval. Since the Schrems decision, the EU and the US have been engaged in discussions to try and agree on a replacement mechanism for Privacy Shield to avoid the need to use SECs for transfers to the US. However, 2021 ended without any real breakthrough. Even if a solution is found between the EU and the US, Max Schrems and others will likely be quick off the mark, and again challenging the validity of that solution. In the meantime, what we are seeing, although not in the UK, what we're seeing in Europe, although not in the UK, is that some are examples of contractual arrangements being challenged where they involve transfers of personal data from the EU to the US. It seems that many EU supervisory authorities are taking a hard line on transfers to the US and are favouring data localisation in the EU. So examples are the decision in Germany on transfer of personal data to MailChimp in the US, and a decision of the Portuguese Data Protection Authority on transfers of personal data to Cloudflare in the US. There's also been the kind of very recent decision from the Austrian Data Protection Authority on transfers of data to Google Analytics in the US. So what we're seeing is more and more pressure on businesses from customers, I guess, from supervisory authorities to try and keep data in the EU. But there are real questions around whether that's actually practical, pragmatic, or realistic in the long term. But in the meantime, businesses are left with a degree of kind of uncertainty as to what to do. So for transfers to the US, it remains the case that for SECs, notwithstanding the SECs are put in place, the risk assessment and any other further measures off the back of that risk assessment are necessary to have any chance of establishing a legal basis under EU GDPR for making such transfers to the US.
Ashley, you mentioned the risk assessment. What do you actually mean by that?
So risk assessment is essentially the issue of reviewing and assessing local laws to ensure proper protection of transfer data, and that was a key concern of the Court of Justice decision in Schrems 2. So to actually take account of this, the new EU SECs require themselves a separate data transfer assessment to be documented before the transfer is made. So this assessment requires you to assess whether those SECs provide protection which is essentially equivalent to the protections in the EU data protection regime, and if necessary, put in place additional measures to safeguard the transferred personal data. So this includes establishing whether the data importer is subject to any surveillance laws that are incompatible with EU data protection laws, which is a really significant imposition on businesses. This requirement is also reflected in the UK consultation, although the UK Information Commissioner's Office has helpfully provided for comment an additional risk assessment tool that would operate alongside the IDTA that I mentioned. But again, we await the final version of this tool. So, I guess in summary, putting SECs in place, now under EU GDPR is much more than a box ticking exercise and takes time because of this additional risk assessment requirement.
So we've talked a lot about the similarities and changes that are happening in the EU and the UK, but will Brexit actually mean the UK is going to diverge on the issue of international transfers?
So while Brexit does mean that the UK can, in theory, diverge from the provisions of the EU GDPR, any changes could have an impact on the UK's European adequacy approval from the European Commission. As I mentioned earlier, it was only given for a duration of 4 years. But even then, if the EU deems that in the meantime, the UK has taken some steps that may cause it to revisit its approval, the EU doesn't need to wait 4 years to do that, it can do it at any time. I know that Joanna is going to speak about the DCMS consultation, data a new direction, and I think Joanna is going to explain why this raises concerns about the UK's adequacy approval from the EU.
And just finishing up, are there any other key data protection implications that we haven't mentioned already?
So one of the implications is, I guess as a final reminder, is that there's also this question of whether or not an organisation needs to appoint an EU or a UK representative under EU GDPR or UK GDPR. The EU GDPR will still apply to many organisations in certain circumstances, and this is because of the extraterritorial nature of the EU GDPR. So where EU GDPR applies to organisations based outside of the EU, those organisations need to appoint an EU representative. So as an example, because of the extraterritorial nature of the EU GDPR, a large retailer based in the UK with no offices, branches or establishments in the EU, but that regularly serves customers located in the EU, needs to comply with EU GDPR in addition to UK data protection laws, and needs to appoint an EU representative. So the appointment of an EU representative is mandatory under EU GDPR for organisations based outside of the EU who process personal data related to the offering of goods or services, even free services, to data subjects in the EU, or who carry out the monitoring of behaviour of EU data subjects. The UK GDPR also contains the concept of extraterritoriality. The UK GDPR will apply to organisations based outside of the UK in certain circumstances, and where that's the case, those organisations need to appoint a UK representative. If this is something that you think applies to you, we offer a fixed fee representative service for UK and EU representatives under our Saltire brand. And if that's something that you'd like to discuss with us or you'd like more information, please get in touch, or you can find more information on our website. So we've reached the end of this section on international transfers. We could do a series of webinars on focusing on this topic. So there have been a lot of developments and there are more developments to come, but hopefully this has been useful, and I'll now hand over to Matt.
Thanks, Ashley. And now for something completely different. So in the last year, we've seen a noticeable increase in questions from clients across all sectors, really, in relation to compensation claims for alleged breaches of data protection legislation. Some of those claims have been well-founded, but many of them are speculative, and where there has been a breach, the amount that's been claimed has been excessive. And I'm sure that probably resonates with a lot of you on the call today. In the last few months, there's also been a few important decisions from the courts that provide some welcome guidance about how they're likely to treat these claims in practice. And I think the increase in these claims is probably partly due to the press coverage surrounding GDPR, some of the high-profile data breaches, and also the subsequent fines. That means that the general public have an increased awareness about their rights when it comes to their data. But also at the same time, it's important to bear in mind that things like the window for making PPI claims has ended. There's also been a reduction in personal injury claims as a result of the restrictions related to COVID. So, for example, in April 2020, there were 68% fewer road traffic accidents than there were in the year before. And as a result of that, what we've seen is this kind of perfect storm of data breach claims becoming a real focus for claims management companies, and they're really starting to process them on a volume basis. In terms of the legal framework, post-Brexit, the right to claim compensation for any damage that's been caused by a data breach is set out in sections 168 and 169 of the Data Protection Act 2018. That allows a person who's suffered damage, either material damage, for example, financial loss, or non-material damage, which would include things like distress, to claim compensation for that. And that's a regime that's completely separate from the powers that the ICO has to issue fines. The first decision I'm going to look at today is probably the most high profile of the decisions, which is that from the Supreme Court in Lloyd against Google, which was handed down in November. In that case, Google had appealed a decision of the Court of Appeal that allowed Richard Lloyd to bring a representative claim, which is basically a group action against Google on behalf of around 4 million UK iPhone users. He was claiming £750 per user because of alleged breaches of the Data Protection Act by Google for tracking their internet activity without their consent or knowledge, and then using that data for commercial purposes, which included things like targeted adverts based on their browsing history. In that case, the Supreme Court ruled in favour of Google. Basically, it found that compensation isn't awarded solely due to that loss of control of personal data, and I'll come back to that in a little while. But a breach also requires the individual to identify that they've suffered a specific loss as a result of that loss of control and claim the damage that's caused because of that. The Supreme Court also looked at the question of representative actions more generally and held that it couldn't proceed in the way that had been envisaged by Richard Lloyd in this case. What they suggested was that actually it would have been acceptable potentially for him to bring that representative action just in order to establish the breach that had been caused by Google. And then that could be used as a basis for individuals to then pursue compensation separately. And in this type of claim, the damage that's suffered by each individual user would have to be assessed individually. So that creates a number of practical problems for the possible claimants in this case, because they're going to need to prove on an individual case-by-case basis, and that likely becomes prohibitively expensive for bringing this type of group action claim. In the wake of that decision, there's been moves from a number of privacy activists, for example, the Open Rights Group, calling for the government to try to legislate to create some sort of mechanism that's workable for collective redress for data breach claims. And so far, the government has said it's got no intention to do so. Similarly, last week, there was the announcement that Meta, formerly Facebook, is now being sued for £2.3 billion in what's actually a very similar type of group litigation. I think Obviously, these types of large-scale group actions are going to continue to grab headlines and commentary, but they've obviously still got quite a long way to go before there's any real clarity about what their impact is likely to be in practice. And at the same time, there's a lot of other cases that are probably of greater day-to-day practical relevance for people who are on the receiving end of these types of data breach claims. They're not getting as much attention. So what I thought I would do is just probably take the rest of my time today just to pick out a few key points from some of them. So as I was saying earlier, I think most of the claims that we are seeing at the moment relate to allegations that aren't financial loss. They're almost always non-material damage. So that includes that loss of control of personal data that was referred to in the Lloyd and Google case. And any sum that's sought as compensation is really for the alleged distress that's being caused as a result of that loss of control. The first important point to bear in mind is that for this type of claim to succeed, as was identified in Lloyd against Google, the data subject has to be able to prove that they've actually suffered loss or distress, and also to explain the effect that it's had on them. So that was part of the reason why Richard Lloyd's claims failed, because he was trying to claim that nominal figure of £750 for each user. And actually what needs to happen is an individual assessment of the loss or distress that's been caused for each case. The second important point to note, and this is one that I'll come back to in terms of other examples, is that in order to bring that claim to court, there is a requirement that the loss or the distress that's been suffered isn't trivial, and that's described often as the de minimis threshold. A good example of a claim that met the de minimis threshold is TLT in the Home Office from 2016. And in that case, asylum and leave to remain applicants had suffered distress when their personal data was wrongly published online. That caused obvious distress to them because of the circumstances, and the claimants were awarded between £2,500 and £12,500 per person. But until recently, there's been very little guidance from the court about when exactly that de minimis threshold will bite, and really how low the bar is for getting over that hurdle. In September, we finally got some guidance on this in the case of Rolf and Vio Waspera Vizard LLP. And in that case, the background was really your sort of standard solicitor's nightmare, which is the claimants seeking compensation for distress from a firm of solicitors who'd mistakenly sent an email that was intended for the claimants to someone else. It was the result of the classic typo, and I think in this case it was just one incorrect character in the email address that meant it went to the wrong person. The email and its attachments demanded the payment of school fees by the claimant to their daughter's school, and it contained the claimant's name, their home address, as well as a statement of account for the school fees, and also a reference to the fact that legal action might be taken if the debt wasn't paid. But it didn't contain any of the claimant's financial information in the sense of their bank or card details. The claimants asserted that they'd suffered distress as a result of the incident, and they sought compensation. The alleged distress was associated with this loss of control by the claimants of their data, and also the amount of time that they'd then spent dealing with the matter. They also claimed to have lost sleep as a result of the incident, and also to have felt physically ill with worry because of it. In this case, the defendant had actually been made aware of the incident fairly quickly, and had immediately then asked the unintended recipient, who wasn't known to the claimants themselves, to delete the email. They'd replied and confirmed that they'd done that, and the email was also encrypted, which meant that it could only be accessed by those with access to that associated email account. So on that basis, the defendant applied for summary judgment on the grounds that the breach couldn't have caused damage or distress above that de minimis threshold. In this case, the judge agreed, and he dismissed the claim, stating that in his view, the alleged distress was plainly exaggerated and inherently implausible, and that it didn't meet that de minimis threshold. The judgment itself is quite scathing of the claimants, and it notes that in this day and age, for breaches of this nature, claims which the judge described as frankly trivial aren't appropriate. He also found that no person of ordinary fortitude would reasonably have suffered the distress alleged by the claimants in these circumstances. And so when drawing it all together, he, in addition to granting summary judgment, awarded the costs of the case against the claimants on an indemnity basis in order to reflect the speculative nature of the claim that they were bringing. Another useful case from November this year is the case of Johnson and Eastlight Community Homes. So in that case, the claimant raised an action against Eastlight in the High Court for a very similar type of breach to Rolf, basically an email sending information out to the wrong person, and seeking £3,000 in damages, as well as an injunction for misuse of private information, breach of confidence, breach of Article 8 of the ECHR, breach of Article 82 of the UK GDPR, and breach of Article 169 of the Data Protection Act 2018. So really throwing the kitchen sink at the claim. And without getting into the detail of the case itself and the background, the judge was really concerned that in this case, those various causes of action didn't really add anything. Eastlight managed to persuade the judge that everything except from the claim for the alleged breach of the GDPR should be struck out on the basis that they were overlapping collateral, and they wouldn't really help with the just disposal of the claim. Importantly, also in that case, the court was very critical of the claimant's decision to bring the claim in the High Court. By the point it came to that strikeout hearing, the claimant had already incurred costs of £15,000 to get there, and it was estimated that she would incur £50,000 to take the claim to a conclusion, set against a claim value of £3,000. So the court noted that in this type of claim, there were obviously risks of a significant adverse costs order if that was unsuccessful, and ordered that the claim should be transferred to the small claims track. So I think that's a really important point, because from a number of the other claims that we've seen, which are often still at a pre-action stage, the legal costs that are said to have been incurred by the other side are often more than triple the damages that are being claimed in that case. And that really creates an issue around proportionality, and it can make them quite difficult to settle. So the decision in Eastlight has some really significant practical implications, not just for cost recovery, because in the small claims track, there is a fixed cost regime, which means that there's only set costs that you can recover even if you're successful. It also means that you can't recover things like a premium that's paid for after the event insurance to meet legal costs. And in practical terms, that means that when the value of any claim is going to be in, generally speaking, the hundreds or low thousands of pounds, and when you've got that cap on legal costs, it becomes more difficult to bring claims that are potentially quite speculative in what could be considered a cost-effective way. So taking those three decisions together, I think there's an indication, at least from the English courts, and there is very little Scottish authority at the moment, that they're alive to those practical issues that some of these claims present, and they're really trying to take what I think is quite a pragmatic approach. I think they also serve as a bit of a warning for anyone who's considering a claim for distress under data protection legislation, because the courts will take action to sanction a claimant where it seems that the claim either lacks substance or there's too many heads of claim that add no value to the overall claim itself. So drawing all of them together, I think the key points to bear in mind are that, firstly, it's obviously really important to consider the possible consequences of a breach at the outset. In a number of cases, if the breach is identified quickly and if reasonable steps are taken to manage the impact of any breach, then it helps maintain that positive dialogue with the data subject, but I think it also reduces the tail risk of a claim coming through afterwards. And also, if one is ultimately raised, it can give you a better argument that you've managed to minimise that loss to the extent that it's trivial. Secondly, where a claim is being made, it's important to think about, firstly, whether you've got any additional reporting obligations that you need to deal with at that time, but also, whilst the trend, in my experience anyway, is towards generally speculative claims, it's important to be objective and to really review the claim on its own merits, and just to try to think about whether the claimant has been able to identify whether they have a financial loss or whether there's good reasons to support the potential distress that's being claimed. And if that's the case, think about whether it's appropriate to try to seek an early settlement of the claim. It might not be agreed, but even if you make that offer, it can sometimes protect you against the legal costs that might be incurred if the claim moves forward. And then finally, obviously, the recent examples mean that where a claim does seem to you to be speculative, there's good examples of the types of preliminary challenges that can be raised with the other side at a pre-action stage. And certainly in our experience, when you respond quite robustly to these types of claims at the outset, it can have a really positive effect in terms of putting them off from bringing that claim and raising proceedings against you. It's obviously an area that's going to continue to develop as the courts are being asked to interpret those individual circumstances under the new legislation. But I think the recent decisions will indicate a common sense approach that's quite reassuring for potential defendants. That's all I was planning to cover this morning. And as Joanna said at the outset, feel free to raise any questions in the chat. And I'll hand over to Joe.
Thanks, Matt. I'm going to change track again and explore some of the common queries that we've received over the past year and the basic principles that we've applied when helping organisations consider how they process special category, or more commonly referred to, health-related data. We predominantly are responding to questions by employers seeking to handle personal data of employees and customers in a legally compliant fashion. Spoiler alert, in the past year, many of these have had a COVID angle. As many of you know, transparency is key when dealing with data protection. So in that vein, I'm going to disclose up front that I'm neither an employment lawyer or an immigration expert. So go gentle on me if you have any questions about vaccine mandates or sporting visas. So here's a flavour of the questions we've been asked this year. Can we ask employees to disclose whether they have COVID or their vaccination status? Can you help us identify the legal basis for processing health-related data? What steps do we need to take to demonstrate compliance with data protection laws when collecting health data? So although COVID has presented a novel factual scenario, the key to answering most of these questions is to apply the same rules that we are already familiar with, albeit accounting for some regional differences in COVID laws throughout the UK. So let's have a look at some of these basic rules. As many of you know, under the GDPR, information relating to symptoms, testing, and vaccination status will comprise data concerning health, which is, of course, special category data. This means that it attracts a higher degree of protection. In order to lawfully collect and use information about health, an organisation will need to ensure that, firstly, it has a lawful condition for processing personal data under Article 6.1 of the GDPR, and secondly, that a specific condition for processing special category data under Article 9.2 of the GDPR applies. So in terms of Article 6, the Information Commissioner's guidance identifies legitimate interests as the most lawful and flexible basis for processing under Article 6.1. It will come as no surprise to many of you that the ICO also warns that this will not always be the most appropriate basis for processing, so watch out. Alternatively, but of less frequent application to most but not all of our clients, some organisations may be able to rely on legal obligation under Article 6.1 as its basis for processing. This may apply where COVID status checks are required by law, as they are in some parts of the UK for certain venues and for certain employers. But it's important to bear in mind that the ICO's guidance confirms that if you're only conducting a visual check of somebody's COVID status, either a hard copy document or digital copy, and do not retain any personal data from that check, it would not constitute processing of personal data under the UK GDPR. If, however, you collect this information digitally or scan a QR code, this will constitute processing. So that's an important distinction to bear in mind. So in terms of a specific condition under Article 9, most of our advice has been provided to employers concerning the collection of health data from employees. In the UK, the most useful condition for processing in relation to health data will likely be Article 9.2b, Employment, Social Security and Social Protection. In the UK, there is a requirement under the Health and Safety at Work Act for companies to take reasonable steps to look after the health, safety and welfare of staff. As such, it is reasonable for businesses to collect certain information, for example, information about a confirmed diagnosis, as part of a company's general duty to safeguard health and safety. In addition to this specific processing condition relevant to employers, some organisations will be able to rely on the public health condition under Article 9(2)(i). Again, this is less commonly relied upon from many of our clients. So having established a legal basis for processing under both Article 6 and 9, organisations have to then ensure that their use of health data is fair, relevant, and necessary for a specific purpose. So how do organisations meet these conditions? Well, given the importance of identifying a legitimate interest under Article 6, we are frequently assisting clients in assessing their legitimate interests. Now, I know many of you will already conduct legitimate interest assessments as part of your compliance activities, but if not, we've developed our own template that would be, and would be happy to guide you through the process. Before relying on legitimate interests, organisations will need to carry out, and most importantly, record the results of, the three-part legitimate interest assessment. Those parts are, firstly, identify a legitimate interest. Secondly, show that the processing is necessary to achieve it. And thirdly, balance it against the rights of the individual and their interests and their freedoms. As mentioned before, when the ICO suggests that this may be the most appropriate basis for processing, each organisation will need to conduct its own assessment to justify this on a case-by-case basis. Given the nature of the data being collected from employees, the ICO also suggests that employers consider the following. Firstly, employment law and your contracts with employees. What do your contracts say, if anything, that may support you checking employees' health data? Secondly, any applicable health and safety requirements that are placed on you as an organisation. And thirdly, any equalities and human rights, including privacy rights, that may be applicable. So let's take a further look at the collection of an employee's health data. From a UK data protection standpoint, collection of employees' health data will be lawful, provided there is a clear and compelling reason to do so. Completing a legitimate interest assessment allows your organisation to assess and document whether recording staff health data will help you achieve a specific goal. Employers in certain industries, for example, health and social care, will be more likely to demonstrate that these activities are lawful, as their employees are more likely to be in contact with patients infected with COVID. However, employers in other industries may struggle to justify this measure, for example, office workers. Employers will have to therefore assess compliance of their proposed collection with the following principles. Firstly, necessity. The ICO has advised that employers should ask themselves whether the information is necessary and whether employers can achieve the same result without collecting such personal information. Secondly, proportionality. Employers should carefully consider whether a blanketed or targeted approach to data collection, depending on the makeup of their business and the makeup of their workforce. And thirdly, fairness. Consider any potential negative consequences for individuals, for example, the impact on those who cannot have the vaccine for medical reasons or those who simply do not wish to have the vaccine. Looking more closely at the necessity test, this may be tested in the coming months when the decisions of some employers, the likes of Next, IKEA, to collect vaccine status data where they're looking to reduce the sick pay of unvaccinated staff. It may be that the necessity test comes under close scrutiny in this scenario. And by way of a final note on record keeping, if your organisation's proposed use of health data is likely to result in a high risk to individuals, for example, the denial of employment opportunities, or you'll be processing health data on a large scale, then you should consider completing a data protection impact assessment before you start the processing of the data. So there's been a large amount of publicity around the no vaccine, no job stance taken by some companies that are operating out with the health sector. The most prominent of these is probably Google. And while this approach seems to be clear and legal under certain states in the US, it'll be interesting to see if this translates to UK law and UK jobs going forward. So as I mentioned at the start, many of the same rules still apply to the collection of health data, so we're not reinventing the wheel here. But I thought I would close with a few reminders of other data protection considerations which organisations need to think about when processing health-related data. And again, these aren't anything new. Firstly, data minimisation still reigns supreme. It's a fundamental principle of the GDPR. That is, that no more information is collected than required for the stated purpose. In relation to COVID, it may be tempting for organisations to push the boat out and ask for all sorts of information about employees, but please don't give in to this temptation. The golden rule is, if you receive information from an individual that is not relevant, just delete it. Secondly, transparency remains key. It should always be clear to the individual why an organisation is collecting the data. And remember that while trying to be transparent, don't lose sight of what your organisation needs to collect or is already collecting. For example, organisations that were already taking reservations and having contact details on their books, although this is now being used for new purposes, such as contact tracing, there were already routine bookings for appointments. So don't conflate these different types of collection when updating your privacy records and notices. So where does this all get us? Well, to summarise, when it comes to using the information about employees for the purpose of dealing with COVID, the position under the law has not changed. Although COVID has presented a novel factual scenario, the same data protection considerations that apply, and I think we've all got pretty good at applying those. So organisations should consider whether it has the correct policies and procedures in place so they can process this information in compliance with law. I'm now going to pass back to Joanna. Thanks.
Thanks very much indeed, Joe. So to finish off our session today, I'd like to talk to you about some of the consultations and developments in recent months. But I'm going to major on the Department for Digital Media, Culture and Sport, or DCMS consultation, and what it might mean for data protection developments in the UK going forward. And ever since the EU GDPR came in back in May 2018, and let's remember that at that time, we knew that the UK would be leaving the European Union because the Brexit vote had taken place. There's been speculation about whether the UK will continue to align its data protection laws with the EU GDPR. And as you'll all be aware, currently the UK has UK GDPR, which is to all intents and purposes identical to the EU GDPR, plus the Data Protection Act 2018, which sits alongside the UK GDPR. And for now, and hopefully for the foreseeable future, we have an adequacy decision that allows Europe to share personal data with the UK.
Joanna, before you talk about the DCMS consultation, what's actually been happening at the ICO recently? So 2 or 3 things I want to talk about in relation to the ICO. First and foremost, it won't have escaped your attention that we have a new Information Commissioner, and John Edwards took up the post after Elizabeth Denham left. He was appointed on the 4th of January, so he's 2 whole weeks into his new job, and there are plenty of challenges for him to navigate, from regulating big tech to trying to keep on the right side of the UK's adequacy decision from Europe, while also looking at the proposed reforms to the UK's data laws under the DCMS consultation. The second thing that I want to touch on quickly is the Children's Code. So the ICO Children's Code is now fully in force after the transition period ended on the 2nd of September 2021. The overarching aim of that code is to protect children's privacy online. And for the purposes of the code, a child is an individual under 18 years old. And the code's based on 15 standards that are designed to safeguard children's privacy online. And the ICO's website has plenty of really good information on what's required by the Children's Code. What types of business need to comply with the Children's Code? So the code applies to providers of information society services, whose services are likely to be used by children in the UK, and information society services are defined as any service normally provided for remuneration, at a distance, by electronic means, and at the individual request of a recipient of services. This includes websites, games, apps, and other online services, even if there is no direct remuneration. So you need to think about things that are being provided for free. And is it specific to UK businesses? No, it's not actually. So if you provide any information society services that are used by children in the UK, you must comply with the code, regardless of whether the provider is based in the UK or not. And what about the penalties for non-compliance? What are they? Yep, I mean, they're potentially pretty high. So the code's designed to complement the UK GDPR and the UK Data Protection Act 2018, and a failure to comply with the code means that it might be challenging to prove compliance with GDPR. So that means that if a provider breaches the Children's Code and there's therefore a breach of GDPR, the ICO can take action against the provider.
and that includes the significant fines that can be applied for breach of GDPR.
And I know there's been something happening with the Employment Code of Practice as well. What have they been doing with that?
Goodness me, yes. So a review of that code is well and truly overdue. It's been in place since 2011. And to say the law has changed significantly since then is certainly no understatement. And in the last few days, the ICO has actually said that they don't plan to issue a new employment code, but instead they're going to create a web-based hub of guidance that will cover various employment topics and issues. And I think what that means is that it will still be some time before we actually get the ICO's updates on employment practices. So more to look out for there.
So you said you're going to talk about the DCMS consultation. I understand it's been quite controversial. What topics are they actually consulting on?
Okay, so the topic really is the future of data protection law in the UK, and the name of the consultation definitely tells you something. It's called Data, a New Direction. So I think we can assume that there is a bit of a change of direction. And there are lots of minor changes proposed in the consultation, but I think the more major changes that are likely to be of interest to those who are involved in data protection law are changes to accountability, data subject rights, data transfers, e-privacy, and research and AI. And I'll cover some of them as we go through this.
So obviously going back to the topic we've already covered, what are the planned reforms to data transfers?
Yep, so I mean, as we heard from Ashley in the first presentation today, following the Schrems II case, there have been some complications in transferring personal data out of the UK and out of the EU to countries that don't have adequacy decisions. So under the DCMS consultation, there are potential proposals to reform data transfers. So going back to the GDPR, Article 46 covers international transfers, and it says that there need to be appropriate safeguards for transfers outside of the UK and the European Economic Area to countries without an adequacy decision. And then Section 49, well, Article 49 of GDPR allows derogations from the prohibition for one-off transfers. But part of the consultation actually suggests that the Article 49 derogations could be expanded to allow repetitive transfers as well as one-off transfers. And then it goes a bit further because it includes a proposal to allow data exporters to decide themselves how to protect personal data that they're transferring. And as Ashley mentioned, standard contractual clauses are currently the most favoured method of lawful transfers. But the DCMS is proposing that contracting parties might be able to use their own contracts instead of standard contractual clauses. So that means no review or approval needed from the ICO. And I understand this is what happens in New Zealand, but it's also really what used to happen back in the old days when we were dealing with the Data Protection Act 1998, for those of us who are old enough to remember those old days. And of course, a move away from GDPR for international transfers is actually one of the areas that could potentially prejudice the UK's adequacy decision from Europe.
You also mentioned accountability. That's clearly one of the essential planks of the GDPR. So what are they proposing there?
Yeah, it's a slightly odd one. So the GDPR's framework for accountability is well recognised. It is quite administratively burdensome. But the DCMS proposals in the consultation kind of seem to replace the existing accountability requirements with other requirements that are just as burdensome and that look suspiciously similar. So I'm not entirely sure why some of those are applying. Now, there is a proposal to make the threshold for breach reporting a higher threshold, but there's no proposal to reduce the current 72-hour time limit for reporting breaches that should be reported. The consultation suggests changing the requirement to keep a record of processing activities, and instead it suggests a requirement for a personal data inventory, which doesn't seem particularly different to me. There is some news for those who are not particular fans of carrying out data protection impact assessments. There's a suggestion that DPIAs, or data protection impact assessments, could potentially be removed in favour of allowing organisations to choose their own approach to assessing the risks of carrying out data projects. Now, I have to admit, I do find the ICO's form of DPIA quite lengthy, but it does at least give a framework and some comfort to users that if you apply the ICO's data protection impact assessment format, it will take you through the necessary steps for compliance with the law. Finding an alternative might, I think, leave organisations wondering whether their DPIA equivalent or DPIA light, if you will, assessment actually complies with the legal requirements. And then the consultation suggests introducing privacy management programs and requiring organisations to allocate somebody who's responsible for the organisation's privacy management program. And it looks like data protection officers can't do that job because they need to be independent, and that seems to disqualify them from a privacy program management role. And what I think that could mean is that organisations who have a data protection officer would also need to appoint somebody else as the privacy program manager. So that's quite burdensome for organisations potentially.
What about DSARs? You know, they're clearly the bane of many data protection practitioners' lives. So what are they saying about DSARs? Yeah, so data subject access requests, known as DSARs. Anyone who's ever had to deal with a complex DSAR knows how horribly time-consuming, difficult, and stressful this can be. And colleagues in our employment team, who, to be fair, will tend to be acting for employers rather than employees, usually face a DSAR as part of the employment claim process. And these are what are sometimes referred to as weaponized DSARs. And the consultation is proposing a cost limit for DSARs. One option that DCMS is suggesting is to base the cost limit on something that's similar to the cost limits that apply under the Freedom of Information regime. And that allows public authorities to refuse requests that cost more than £600 for central government or £450 for other public authorities. And the way the cost allocation is allowed under the Freedom of Information regime is based on £25 per staff hour. So that means that there would be a cut-off at, say, 24 staff hours if you're applying a £600 limit. And a staff hour under Freedom of Information is an hour spent by a member of staff or by an external consultant, such as a lawyer, for example. And I suppose as someone who's often on the receiving end of DSARs that come into clients, I would certainly welcome an upper threshold. However, this does seem to curtail individual data subjects' rights. So again, I think this is something that might prejudice the UK's adequacy decision from Europe. And are there any other areas of interest in the consultation you want to mention?
Yep, there's a proposal to create a list of legitimate interests for which no legitimate interest assessment would need to be conducted. And under this proposal, the legislation would recognise the listed processing purposes as always outweighing the interests of the individuals. The list's quite limited, doesn't seem terribly controversial, and it would seem to reduce the burden of the documentation obligations. There are also proposals on AI and machine learning, on reform of the ICO, on reuse of data that would be quite helpful to universities and others carrying out research. And there are some limited reforms proposed to the privacy and electronic communications regulations. They cover electronic marketing, and that would be increasing fines for nuisance communications and also a call for views on how to reduce fatigue for cookie consents. And all of those areas are really interesting, but I think they're a bit more narrowly focused than the broader reforms that I've mentioned. So what I'll do is I'll leave people to read up on those that are of particular interest. And I'm just looking at the time now, and we're at 10:58, so I think we should probably bring the session to an end. I do hope that those who've attended have found it useful. We'll be sending out the link to view this webinar, and we'll also send you out our post-Brexit data protection checklist so that you can check what you have done and, just as importantly, what you should have done following Brexit. So we look forward to seeing you at our next data protection event. In the meantime, thanks for your attention today and have a very good day. Bye-bye.